And Judge, when the state says a bunch of other lawyers that filed those, we're among the bunch. I'm just
Many.
sure that we're in.
Okay, sir.
Thank you. That's from Mr. Nichols.
Yes, sir. All right. I think we already talked about the motion to sever the counts. You said you're going to argue that, and we'll be able to argue that in just a little bit. There's a motion to sever this trial.
Can you hold on?
Are you prepared to argue that, Mr. Irwin?
Yes, those are all motions that Mr. Floyd wrote, but I know that the court wants to get those heard, so I can go ahead and do that.
What about the motion for bond after in-camera inspection of discovery?
You want to do that one? I can do it. Yeah, we can do that, Your Honor.
All right, so go ahead, Mr.
Oh, and Your Honor, we did actually get a speaker, so.
That's one. I have low confidence in your technical.
I have low confidence in mine as well, Your Honor.
Let's see if we can't get it. Get that just a little bit, okay? All right. Yes, sir.
Oh, yes, Judge. Your Honor, I don't, this court has never to this day had an actual picture of the nature of these charges as it pertains to Mr. Farley, because what we kept having is proffers that turned out not to be true. Your Honor, I know with Defendant Kitchens, there was some back and forth about this, and we got into, well, it's a preponderance standard about how the judge used that. But
Yeah, it's the difference between it's a pretrial and also federal and state court. It's different in federal court.
Right.
Georgia hasn't gone that far. Proffers are acceptable in state in criminal cases. It's unfortunately that's just the way that
Right.
our systems, our laws develop in terms of that. So, is there anything more you wish to add to that, or?
Well, yes, Judge. I just want to distinguish Mr. Farley from Mr. Kitchens because I was there for that hearing, and I thought it did stand out to me because the proffers that have been made about Mr. Farley that led to a denial of bond at the last hearing turned out to just be flatly false in a black and white way where there's no gray area. There's just no gray area at all. Mr. Geary got up here and said, Your Honor, he tried to hide the phone and he tried to hide the gun, but we got him. We got him. And then I do a motion to physically inspect. He stands here to Your Honor's face and arranges a physical meeting for me to inspect the gun and the phone. And then 20 minutes later in the hallway, he tells me, oh, actually, we don't have a gun and we don't have a phone. So that whole dramatic allegation against Mr. Farley turned out to be flatly false. There is no gun, there is no phone, and Your Honor is about to hear those calls. I was ambushed by that, Your Honor. And so he's talking about jail calls. I don't know what he's talking about. Now I've heard them. They're just flatly not what he said. Your Honor is about to hear them. And it's just, there's no preponderance to weigh. Was there a phone and a gun seized from Mr. Farley that he attempted to conceal? No, there is not. And he doesn't even have a window tint violation. So he has no criminal record, no arrest record, never even been accused of a crime, presumed innocent here, can't be considered to reoffend because he's never offended before. How can you redo something that you've never done before? When you put re at the beginning of a word, that means do it again. He's never offended, and he hasn't offended here, and he's presumed not to have offended here, so he can't be thought to reoffend. He can't be considered a danger to the community. Your Honor heard from his principal that he'd never even been in a fight at school, so he's never been violent, has no risk of being violent. And then I would assume that Your Honor made the prior ruling based on a risk significant enough under Ayala about tampering. Because as far as a flight risk, he's never missed anything. He's never been accused of anything, and he's prepared the way the other defendants were to just be at home on an ankle monitor. These days, even the legislative notes about bond, Your Honor, say that we have technology that can make at-home detention on the same level as detention in the jail. And so, Your Honor, there wasn't any ruling, I thought, about him being a flight risk, but then it seemed by Mr. Geary's false proffers to the court that that was a denial. Also, Judge, I had asked for Your Honor to review in camera some of the evidence that the state's talking about, for example, the BP video. where they falsely tried to say Mr. Farley went in and greeted people at the store, when actually he walks in, sees the people at the cashier, and then purposely doesn't greet them. So again, that's not preponderance. There's no debate about that. He did not greet them in the store. And I wanted Your Honor to see that. I also wanted Your Honor to see some of these music videos where, first of all, I think ridiculous to attribute lyrics of art to real life, but even if you do, he's not even mouthing the lyrics in the word. He's a personal assistant to Mr. Wani Lee, the creator of the persona Slime Life Shorty, and he's there and he's in the videos. Personal assistants are always in the videos. It's a hip-hop trope, Your Honor, to have a video with you and your friends in your neighborhood. So he's not even saying the lyrics. I wanted Your Honor to see that. And there's even times in the video where he's like on his phone and Wani Lee has to like turn him around and be like, dude, we're filming a video. And so that's what I wanted Your Honor to see, because they were characterizing it falsely in their proffers. And so then Your Honor said, was that in your motion? I responded no. So that's why I did refile a motion so that Your Honor...
There's a change in circumstances, is what you want me to consider?
No, Judge, actually, because there's never been a clear view of this situation as it pertains to Mr. Farley. The state, by the way they revealed discovery and mischaracterized it and said proffers that weren't true, robbed the court of all situational awareness to be able to see the nature of the charges as it pertained to Mr. Farley. So I'm not arguing a change in circumstances. I'm arguing that this court has never had a clear view of Mr. Farley as far as the nature of the charges, which is a bond factor, not the merits of the evidence. But the nature of the charges have always been mischaracterized. And when I tried to correct them, you'll remember Mr. Geary didn't respond to any of that. He didn't respond to any of my comments about the word slime and the fluidity of language and how language is context-based and my ideas about meaning and how they conflict with his ideas about meaning. But he didn't address any of that. He went straight to, well, Judge, sure, that's all true, but we got his gun, we got his phone, we heard him telling his girlfriend trying to get rid of it, but we got it, Judge. And that was false. And so, Your Honor, I don't think we need a change in circumstances. There's never been a time where the court got an accurate view of Mr. Farley and the nature of these charges to be able to analyze this under Ayala versus State, which importantly says significant risk, not just risk. And so, Your Honor, I don't think that the court's ever been in a position without an in-camera inspection of some of the evidence and without knowing now that what Mr. Geary said on the news directly to the camera was just not true. And now that's out there. So I want that out there that that wasn't true. And so Your Honor made a ruling based on things that weren't true. So we shouldn't need a change in circumstance. The only change in circumstance is that this is the first fair and transparent and honest bond hearing that Mr. Farley is going to have in this case. And I do want Your Honor to post a bond, to grant a bond, just in case we don't start on January 9th, Your Honor. And so we're willing to submit to any conditions, any kind of house arrest, any kind of reporting, any kind of ban from social media, technology. I mean, he can run his business through his assistants. He doesn't even need to have a phone, Judge. He can not have a phone and just sit in the house and report however Your Honor wants him to report and tie an ankle monitor wherever we want to tie it. It doesn't matter. But he'll be monitored 24/7. And he's not a risk on any of the bond factors, let alone a significant risk. And that's been acknowledged apart from that last proffer by Mr. Geary at the last hearing that was just not true. And Your Honor is going to also hear these jail calls that were Mr. Geary's response to my proffers, and they're also not the way he said. And so, Judge, I just ask for a reasonable bond to this particular defendant in the amount of $50,000.
All right. Thank you, sir. Any other officers want to say?
Yes, sir. Your Honor, well, first of all, I think your thing's still here. Okay. Your Honor, first of all, can everybody hear me? As to the, yes, I think we were transparent with the court before that Mr. Geary got the facts wrong. That happened. However, here's what he didn't get wrong. The jail calls are, I know Mr. Menendez, I respect him as, you know, what he's saying, but the jail calls are patently different than what he's saying. It's clear based off these jail calls, the only reason we did not actually find the phone and did not actually find the gun were because Mr. Farley arranged to ensure that we never found those items due to ensuring the phone was disposed of, that one of the guns was taken to Farley's family members. That's really clear from the jail calls. And so that's first of all. Not just, I don't believe the court needs to actually hear the jail calls to make. I just wanted to rebut that first of all. Second of all, Your Honor, Farley is currently facing murder charges for the murder of Mr. Drinks. He was incarcerated for Mr. Drinks' murder prior to this indictment. That was a brutal murder by gang members in a rival, in a gang dispute, essentially. Farley was seen at a gas station immediately before the murder. He was wearing YSL apparel with the word slime on them. He was with his co-defendants that murder at the gas station. That's like immediately before the shooting. Additionally, evidence shows that Farley was at essentially a YSL trap house, like a house where they commit unlawful activities. Within about 48 hours after that shooting, it was so recent, this shooting, that one of the co-defendants actually was still wearing the same clothes as during the murder. The state also has evidence that shows that Farley has some access to a cell phone while he's within the Fulton County Jail, and I attached this to our motion as State's Exhibit A. If the court has a copy of my omnibus motion I filed, it's attached to State's Exhibit A. It was located on, as recently as December 3rd of 2022. It was posted on an Instagram account that was named ysl.rude, and it showed a picture of Farley that appears to be, I don't know the legal term for it, but a selfie. It's where he's holding a camera and he's taking a picture of himself while displaying a middle finger. It appears that that photo was taken in the Fulton County Jail. Whoever created this post, presumably a YSL associate or sympathizer, posted this selfie of Farley with the comment, "Free the creator of Massa." I think, as Mr. Menace agreed, Massa is the clothing line associated with YSL. It means the YSL slogan, "Make America Slime Again." Additionally, Farley's jail calls show that he has communicated with co-defendants through third parties. For example, he'd call a girlfriend of a co-defendant, they'd contact with that co-defendant. So for the reasons stated above, and additionally because the nature of this charge is a murder charge, in addition to all these gang charges, he was a participant in a very serious homicide, a shooting of a young man, only less than a year ago. We would ask that this court deny bond, but certainly we also would hope that the court will consider the jail calls as well, because I think that truly solidifies why Mr. Farley cannot have a bond. But additionally, Your Honor, there's been no change of circumstances, although the only difference between what Mr. Geary, he believed that the gun and the phone had been recovered. That was the only error. Other than that, everything he said was accurate, and the jail calls do reflect that Farley attempted to hide these items. He is charged for murder. And again, it does look like, whether or not he currently has a cell phone in his possession, that photo being posted so recently of a selfie, it's not a picture that someone took of him. It's clearly that he took of himself while giving a middle finger. It's attached as Exhibit A in the jail. Would support the denial of bond, Your Honor.
Just briefly, just want to cover those things. Just the mere fact of facing a murder charge doesn't make you a bond risk. Otherwise, everyone that's presumed innocent and accused of murder wouldn't get a bond. And again, Judge, it's not YSL apparel. That's the part that Don Geary left unanswered last time. I don't want to give the state any ideas, but on the Make America Slime Again Instagram account, Mr. Williams is not the only one wearing the clothing. And Make America Slime Again has nothing to do with YSL explicitly. There is also artists like Future and T.I. on the Instagram wearing the same hat as Mr. Williams and that same shirt that Mr. Farley is wearing on the BP video, Your Honor. And the shirt says slime or die. It's just a play on words like trap or die. Your Honor, again, the state still, by their proffer in a black and white way, has failed to articulate any party to any crime. If you listen carefully to what Ms. Rosenwasser just said, all she talked about was presence and association. He's at the BP. He's with these people afterwards. He's wearing a shirt that has the word slime on it. Your Honor, Make America Slime Again is an LLC. It's an official company. It has nothing to do with just YSL. It was Mr. Farley's attempt to get any proximity to any artist of any kind of attention, when attention is such a commodity these days, especially for the clothing business. And if you notice too, the shirts that Mr. Wani Lee is wearing in his videos, because Mr. Farley and him are close friends from since they can even remember, and he is his personal assistant paid by Alamo Records in an official way, Mr. Wani Lee is also wearing shirts from a different clothing line. I think it was True Detail or something like that, and it's some relative or other person that he's trying to put on. So, Your Honor, this is not YSL apparel. This is a person, an entrepreneur who is close to Wani Lee, has a business relationship with him, and then networks with musicians and other types of people to make his clothing more visible. And so, Your Honor, again, there's just presence, there's just association, and as far as access to a phone, that doesn't show anything. It shows that he's on the phone in the jail, but it doesn't mean that it was his phone, doesn't mean that he posted it. That account that did the story wasn't him. You can reshare stories, you can post stories of other people. So just like when we had that proffer about Mr. Kitchens where someone said, oh, I'll do anything for Gunna. If someone wants to post something with an image that they somehow got because a camera from a jail phone was on Mr. Farley for a second and took a picture of him giving the middle finger, okay, he didn't decide to post that. He didn't decide to someone say free him or anything like that, Your Honor. So again, I don't see how being in a phone image makes you a risk on any of the bond factors, Judge.
I want to listen to the...
Okay.
I'm going to give the closing answer a minute. And the settlements. So I'm going to plus this is out that time. So I'm going to take 10 minutes, and then we'll come back and I'll finish up the
Thank you very much.